Sani Babu, I need one help, huh? In your WhatsApp, I have given one YouTube link, my class link. You click it and see my voice is audible or not. No, no. Uh, hmm. When I talk, it's you can hear it or not in YouTube. Okay. Hmm. Sound will come now in this system. No, I need to know it's working or not. There it will come in your phone. Huh? Then click the link and see students can hear me or not. Huh? 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 Hello? Hello? Huh? Oh, okay, okay. I was asking Sani Babu for that. Oh, okay, okay. Thank you. Huh? Then why I will start. Okay, thank you. Sorry. Hello everyone. Today's class is on Semiconductor IC Layout Design Act. So this is another kind of IP Act that we have been learning all these days. We have covered patent, design. By the way, am I audible? I hope I am audible. Okay. So we have covered patent, design, trademark. What else? The infringement. I covered in the last class. So today's class is another one, Semiconductor IC Layout Design Act 2000. The number 2000 means this act uh, was enacted in India in the year 2000. Okay, let's start it. So what is integrated circuits? You guys are not from science stream, right? But some of the science streams are there. So what is integrated circuit? Does anybody know? Instead of good evening, hi and bye, if you can type some answer, that will be helpful. If you have any question or anything you want me to slow down, so you can drop that message in the chat box. If you just write hi ma'am and good evening ma'am, so I'm actually missing if any important lines are there. Okay, so in case nobody has any idea about what is integrated circuit, so integrated circuits are commonly known as chips or microchips. They are the circuitry element, electronic circuit element, which uh, is common part of all electronic apparatus, all electronics equipment like transistor, diode, resistor. Uh, they will be assembled in a certain order on the surface of any semiconductor material that is usually silicon. So in that case, the whole assembly will be called as integrated circuit. So we call it as chip or microchip also. What is the use of integrated circuit? In modern technology, integrated circuits are essential elements for a wide range of electrical products, including articles of everyday use such as watches, television sets, washing machines and cars, as well as sophisticated computers, smartphones, other digital devices. So in all the digital devices nowadays, as you can see, the size is uh, I mean, they are reducing the size, right? The size is getting reduced year by year. So basically, we are using all the chips together. So we are able to bring down the size of that device. So nowadays, almost in everything, these integrated circuits are being used. Developing innovative layout designs of integrated circuits is essential for the production of ever smaller digital devices with more functions. As I said that it can reduce the size of the device, and of course it can add some more functionality if you are adding some more integrated circuits with more function, whatever you want. Why does these circuits, integrated circuits, they need some protection? So creation of a new layout design requires an enormous investment and time from highly qualified experts. So please don't share your screen, it's quite disturbing. Please don't share. So, creation of a new layout design requires an enormous investment and time from highly qualified experts, but the copying of that chip is very easy. So, it may be done by photography. If you have one mobile, every mobile has got camera these days, so you can just take one photo of it and go back your home, and you can just put whatever they have kept on that chip, so you will be just able to replicate that circuit design. So copying is very easy. So here I have written that it may be done by photographing each layer of an integrated circuit and preparing masks for the production of integrated circuit on the basis of the photograph that has been obtained. In order to prevent such unauthorized copying of layout designs and to provide incentive for investing in this field, the layout design of integrated circuit is protected under a sui generis intellectual property system. I have told you earlier also, sui generis means some specific law. For example, we have uh, different specific law for design. So we have Industrial Design Act 2000, that is called sui generis law. But in the US, they don't have a specific law for industrial design. They have design patent. Okay, they have plant patent, but we don't have plant patent. We have sui generis law for plant, that is called Plant Variety Protection and Farmers' Rights Act. So these are called sui generis. That is some dedicated act just for that system. Okay, so we have for IC layout we have one dedicated act for that. It doesn't come under the regular design act, right? For regular design, industrial design, when I was uh, talking about industrial design few days ago, I told you that any aesthetic property of the article that has an appeal to the eye of the customer will be called as industrial design, and you can apply for it and you can get it registered. But this is very different from that design because this has got some functionalities associated with this IC layout. But that design doesn't have any functionality. That is just how it looks like. But in this case, the semiconductor IC layout design, it's just not about how it looks like. It's about how it works like. So it's not similar to the Industrial Design Act. If there is any question, I can take it. Is there any question? No. So, why it cannot be protected under other IP laws? First of all, this is not patentable as it does not involve an inventive step. So, when I was talking about patent, I have told you that for patent, there are three criteria for patentability: novelty, inventive step, and industrial applicability. So, the inventive step will not be qualified for this IC layout design. Okay, there is no inventive step in that, so it cannot be it cannot satisfy that inventive step criteria of patentability, so you cannot get a patent for that. Apart from that, there is section 3 in Indian Patents Act where they have clearly mentioned that this IC layout designs are not patentable. Okay, it is clearly mentioned under Section 3 of Indian Patents Act. I think I already shared that Section 3 slide. What are the subject matters that is not patentable? So this is among one of them. Section 3(o) says that IC layout designs are not patentable. Okay, so this doesn't come under IP law, so you cannot protect it under patent law. Then under industrial design, just I have told you, since they do not determine the external appearance of integrated circuit. Here, they are not about just the external appearance of the integrated circuit, but rather the physical location within the integrated circuit wherever they are keeping it. So I keep telling on this over and over again that on your chip, if you replace one diode by one triode, or you replace one resistor by uh, you increase the resistance of that resistor, if you put it, or you earlier you had kept it in parallel, now you are putting it in series, so like that the function will completely change, right? The output result will completely change. So based on the location of the elements on the IC layout, the function will completely change. So it doesn't at all matter how it looks like, but it matters on which location that is actually kept on. Okay, so this is very different than the industrial design, and it cannot be protected under Design Act. So here just it is written
అయితే చెప్పినాము పేరు పేరు చెప్పినాము బాగా వచ్చేస్తాను అయితే మనకి శనివారం 9వ తారీఖు ఉండాలి.
if you guys keep on talking, you are wasting your time and my time. Anyway, so it cannot be protected under copyright also, as it might be too general to provide specific protection of layout design and integrated circuit design under Copyright Act. So please remember, it cannot be protected under any other act. There are some international legal frameworks, just the way I told you about PCT for patent, Madrid for trademark, like that. There is Washington Treaty on intellectual property in respect of ICs, that was there in 1989. Its substantial provisions have been incorporated in the TRIPS agreement also. In most countries, a special law, the sui generis law, like in our country, on layout designs of integrated circuit exists. But in some of the country, it doesn't exist. They combine with some other laws. For example, sometimes it's called mask work. In the US, they call it mask work. We just call it IC, semiconductor IC layout design. Okay. An application for registration has to be filed in each country in which the protection is sought. So again, it's about the territorial right. I told you, right, that all the IP rights are territorial right. In the country where you are applying for that right, you are going to get that right in that country only. In any other country, you cannot enforce your right unless you file over there and you get the grant over there, right? So this is called territorial right. The Act and Rule in India, Semiconductor Integrated Circuit Layout Design Act, that came into the picture in 2000, and the rule came in 2001. This is just a photo of one IC layout. Then definitions in section 2H of this IC Layout Design Act, layout design definition has been mentioned. That layout design means a layout of transistors and other circuitry elements, and includes lead wires connecting such elements and expressed in any manner in a semiconductor integrated circuit. So that is the definition of layout design mentioned in section 2H. Section 2R talks about semiconductor integrated circuit. For is the definition of semiconductor integrated circuit. You must be worried about why do you need to know the definition. In law, you have exact one definition. Whatever is not mentioned in that definition is not covered, and that's very strict. So when you go to court, the court will interpret this thing just based on this definition. There will not be any other consideration or something else. You just have to uh, obey this definition. So these definitions are very important in case of legal rights. This is another legal right. All IP rights are legal right. So did I read it out? Semiconductor integrated circuit means a product having transistors and other circuitry elements which are inseparably formed on a semiconductor material or an insulating material or inside the semiconductor material and designed to perform an electronic function. Right, so all the IC layouts, they are designed to perform a certain function. What can be registered under this act? So basically, what are the criteria of this registration? Again, going back to that patentability criteria, that novelty, inventive step, industrial applicability, like that, here the criteria is it has to be original, the design, it has to be distinctive, it should be capable of distinguishing from any other layout design, and it has not been commercially exploited anywhere in India or in a convention country. So those are the criteria for registrability. Now, who can file? A creator of a layout design who has principal place of business in India, or if the person doesn't carry out the business in India, has a place of service in India. Only those people can apply for registration. When to submit the application for registration? Once a company or an individual launches a new product with some unique features, he, she, or they can submit the application with the drawing or mask and layout of the circuit for registration. Okay, who can file and when to submit the application? Registration process, cycle and time required. First, filing of application by the creator of the layout design at the SICLD registry, that is Semiconductor IC Layout Design Registry. Okay, this is not patent office. So when you file patent and design and trademark also and geographical indications also, so those are the IP offices in India. But in case of IC layout design, this is something different. This is a registry. This is called a registry. So that is SICLD registry. So you file the application, then the acceptance of application will happen. Register may accept. Register means the head of that SICLD registry. Okay, it's not our university register, it's where you are filing your application. That head of that registry is called registrar. When you file a patent application in patent office, that head is called controller. Here it's called registrar. So the registrar may accept or refuse the application or accept with some modification. So this will be the similar case in all the IPs. When you file it, they may accept it as a whole or they may ask you to modify it. So you modify and send it again, then they may accept it or they may reject it uh, just at the beginning. So like that, uh, So like that, it may so happen that they may accept or they may refuse or they may accept with some modification. The accepted application shall be advertised within 14 days of acceptance. So when they accept it, within 2 weeks of that, they will advertise it. Okay. Any opposition to the advertisement can be filed within 3 months. Okay, you may need not remember these months and days. If you remember, it's well and good, but it might be a bit difficult. This is just for your understanding the whole process. If you can understand, this is basically similar for all the IP acts. So when it is published, anybody can oppose. I remember somebody was asking me whether it can be cancelled or not after an IP right has been registered. So here also the same case, when the application has been accepted, somebody can oppose it by seeing the advertisement. Then you have to file the counter statement to the notice of opposition, if any, to be filed within 2 months from the date of receipt of copy of notice of opposition from the registrar. A copy of counter statement provided to the opposition party also. So these are all the procedure that will happen when someone is opposing your design. The registrar may take hearing with the parties. He may ask both of the parties to come and listen to their issues, or it can happen over video conferencing also nowadays. Then the registrar will decide on the originality of the layout design and grant or reject the application for registration based on the conclusion reached by him. The aggrieved party can appeal to the appellate board. Nowadays, the appellate board is not there. You have to file it in the civil court. for relief or whatever. For example, if you are the owner of this design and somebody else opposed it and there was a hearing at the registry and the registrar decided against you, so you are the aggrieved party now because the decision was not in favor of you. So you can challenge it in a civil court for relief, for your relief. Okay. What are the rights obtained? So, like any other IP rights, when you get the grant, you get some rights for that. So here the exclusive right is to prevent or stop others from commercially using the protected layout design. So basically, this is also the same for all IP rights. The original topography cannot be reproduced entirely or partly. So remember, partly also you cannot reproduce it without the consent of the owner. So the original topography cannot be reproduced entirely or partly for commercial purposes by others without the authorization of the right holder. So you need to take the authorization from the right holder, from the owner who has got the grant. Without that, you cannot use this thing, commercially use this thing. A protected layout design, an integrated circuit, or an article which incorporates an unlawfully reproduced layout design cannot be imported, sold, or otherwise distributed for commercial purposes by others without the authorization of the holder of the right. So the same thing over and over again. If you study one IP Act, you will be able to understand what are other IP Acts, but there will be some sections and rules that you need to remember. If you are studying the law, if you are not studying the law, you just need to remember the terms. Like here I am talking about the term of registered IC layout design, that is 10 years from the date of filing or from the date of first commercial exploitation anywhere in the country, whichever is earlier. So does anyone remember how much is the term for a patent grant? Let me see, anything is there in the chat or not. Just a good evening. Okay, if you guys are not sleeping, then anybody remembers how much is the term? When a patent is granted, for how many years it will be there in force? Who is saying 10 years? I'm talking about patent. Jaya, are you talking about patent? It's not 10 years. Anybody else? I hope everyone is sleeping. Okay, so for patent it is 20 years from date of filing. For trademark it is 10 years. And after that you can renew it forever for 10 years, 10 years, 10 years, like that. As long as the mark is used in the market. That is for trademark. But for patent, it will end after 20 years. You cannot renew it. So trademark is 10 years, 10 years, 10 years. Patent is 20 years. Design is 10 years. You can renew it for another 5 years. So 10 plus 5. And this one is 10 years. That's it. So for term of registered IC layout design is 10 years from the date of filing or from the date of first commercial exploitation anywhere in the country, whichever is earlier. Filing or exploitation, whichever is earlier, from that the 10 years will be calculated. To obtain protection, any Indian or convention country citizen should have place of business or address for service in India. That I just told you, right? That you need to have your place of business or your service address you need to have in India. Then in that case you can file for the uh, registration of that IC layout design. And this also I have already mentioned that under section 3O of Indian Patent Act, a topography of integrated circuit is not patentable. So under the subject matters that is not patentable mentioned in section 3 under Indian Patent Act, under section 3O this has been clearly mentioned that ICs are not patentable. When a layout design cannot be registered. So just like in this slide, here what can be registered. So if someone asks you what cannot be registered, just keep the negative things. So if something is not original, it cannot be registered. If something is not inherently distinctive, it is not registrable. Then if it has been already commercially exploited anywhere in India or in a convention country, then also no. Then inherently not capable of being distinguishable from any other registered layout design, so that is also not registrable. So you have to just go to this slide where it can be registered. It is mentioned. What is the slide number? Okay, well, I will send you the slide, you can just see it. So when someone asks you what cannot be registered, you just put the negative thing over there. Okay, so those are the 4 things that it cannot be registered. Then remember something, uh, a registered layout design that has not been exploited commercially for more than 2 years from the date of registration of application shall not be treated as commercially exploited for the purpose of this act. So this is some special thing in this act, that from the date of registration, if it has not been exploited commercially, it will be treated as not commercially exploited. Okay, within 2 years if you cannot do that. Then infringement, last time I told you about infringement. Does anybody remember? Oh, it's already written on the screen. Uh, Anyway, so infringement is the reproducing, importing, selling, and distributing registered IC layout design for commercial purposes. That act will be called as infringement. So if you reproduce or import the IC or sell it or distribute it without having the authorization from the registered guy, from the owner, so that will be called as infringement. A layout design created on the basis of scientific evaluation of a registered layout design shall not constitute any infringement. So this was there in Patent Act also. When you use something that has been patented for teaching someone, for example, I am giving all these slides. So am I violating anybody's? This will be copyright. This is not registered design, right? Am I violating? No, I'm not, because this is for the purpose of teaching. And then if you do some research also, so if you have some IC layout, you saw some registered IC layout and then you took it and you are doing some research on it, that is still not infringement, because teaching and research, these are permissible. You don't have to worry about infringement over there. If you are commercially exploiting it, then only it will be called as infringement. If you are just using it for scientific evaluation, research and teaching, that is not infringement. That is an important part. I hope you remember. Then infringement remedies, here also criminal remedies are mentioned in the act. So just like copyright and trademark, IC layout design also has criminal remedies. But for patent and design, only civil remedies were there. I told you in last class also. What are the infringement remedies for this IC layout design? Infringing the rights of a registered proprietor of a layout design is punishable with imprisonment for a term that may extend up to 3 years. So if you infringe somebody's right in this IC layout design register, you don't take the permission from that owner, and if you are infringing, you may go to jail, and that may extend up to 3 years. So be very careful about it. The criminal provision is there in this act, and fine not less than 50,000, and it may extend up to 10 lakhs, or with both. So you may go to jail also, and may have to go 10 lakhs also. So that's a hell lot of problem. So please be very careful about when you are using some IC layout or when you are copying it. Please don't copy anything that has been registered. Then falsely representing a layout design as registered. So if you have not registered it, and if you are creating something, if you have created something and if you are saying other people that it has been registered, that is also punishable with imprisonment. So for there also you can go to jail, but that will be maximum 6 months, because that is not that great crime uh, under the eye of the law. You are just lying to other people, just I have registered it, but actually you didn't. So in that case you may go to jail, and that may extend up to 6 months. But if you infringe that, you may be in the jail for 3 years. So there's some difference. But here also, the fine is there, and the fine may be maximum 50,000. On top of that, you can see the fine may be 50,000 to 10 lakhs. So when you are infringing, there's a hell lot of criteria. You can go to jail for 3 years. You have to pay 50,000 to 10 lakhs. But when you are falsely presenting that some design is registered, which is not, in that case, it will be 6 months of jail maximum and maximum 50,000. So better don't do any of such thing. Okay, here I just took a screenshot of the registered ICs in India. So this is very interesting. If you go to the, you can see the website over there is ICLDR. So Semiconductor Integrated Circuit Layout Design Registry.gov.in. So that is their website. You can go there, and there you have to click the certificates issued. So you can see this is really a shocking scenario that only two IC layout designs have been registered in India. Now don't ask me why. Maybe you guys can come up with something and you guys can file it. So one in 2013 and one in 2016. The one that was filed in 2013 was registered in 2015. That is from Bharat Electronic Limited, and another one is from Indian Space Research Organization ISRO. So only two has been registered. Only two have been registered. Not sure why, but there is a specific act for that, and a separate. You can see this website is there. Just maybe because of some lack of awareness, people are not filing it. So if you guys have anything, you can definitely go ahead and file for it. So our university will be very proud of you guys. This is the only act in India where the filing is uh, really scarce. So these are the reference material I have taken from. One is WIPO, World Intellectual Property Organization, assuming that you guys don't remember. So if you go to wipo.int, there under patents, also these integrated circuits are mentioned. So there also you can see what are the basic criteria for registrability and all these things, because all these things are under TRIPS. So every country will be, TRIPS compliant. So it's similar. And if you wanna just read the Indian thing, you can go to the next website, sicldr.gov.in, and this frequently asked question. You can go there, and I've just taken few of the points from these sites. So that's all for today. Now I'll be open for question. What is the time? Yeah, some 20 minutes maybe. So I'll stop sharing. Oh, okay, you guys wrote 20. I'm so sorry I didn't see them. Somebody wrote 60. Oh my god, Shweta, why are you writing 60? 12 years. Excellent. I have never heard of any IP right that has 12 years of term. For Shweta, I remember your name from my last class. So that 60 years is for copyright. Okay, let me go through all this confusion. 12, 20. What about this 12? I am really interested to know from where this terminology coming from. From which calculation this 12 is coming. I want to know the answer from Nilima and Srinu. Please tell me from where this. Oh, somebody is saying I cannot catch the words. I'm so sorry. I didn't see that. Again, I'm speeding up. Somebody is saying voice is not coming. Somebody is already ready to go attendance link. Okay, Sweta, you heard right. So for copyright, that will be if I am the copyright owner. If I write one poem today, so the term of that copyright will extend after I die till I die. That is my copyright. After I die, 60 more years, 60 more years, the copyright will be there on my name. Okay. So that is copyright. The lifetime of the author plus 60 years. That is copyright. For patent, it is 20 years from the date of filing. For trademark, it is 10 years from the date of filing, then go on renewing it for 10 more years every time for an infinite number of times. And then industrial design, 10 years from date of filing, then another 5 years you can extend, and this one is just 10 years. So you can understand also why these things are there. For example, patent, patent is about technology. Maybe after 20 years the technology is not in the market anymore, so in most of the cases what happens, the patent owner does not even renew the patent for all the 20 years. After 12 or 15 years they will just stop it. So they don't renew it because the technology is not in the market anymore. But for copyright, the thing is not like that. This is not in the market or something. It's not like that. That is a creative. That is something creative. Uh, uh, the creation can no longer go out of the market or things like that. So the copyright lives for a longer period of time. Total lifetime of the author plus 60 years. Okay. And then trademark is, again, you cannot just stop the trademark. If it is in the market, for example, Google will always be there, so you cannot just ask them, no, your trademark is over. So they have to go on renewing it every 10 years for an infinite number of years. And for industrial design also, maybe the design will go obsolete, so most of the time people don't even renew the design after 10 years. For the next extra 5 years they don't even renew it, they just take it for 10 years. I will give the attendance link, just listen to me what I am saying. And this integrated IC layout design, that is also something we can extend that time period. For which one you are saying? Okay, I will write here if somebody has any question. No extension patent, trademark, 10 years, infinite extension. Please don't write anything else in between, because I am writing something for everybody. Design, 10 years, 5 years extension. What else I told? IC layout, 10 years, no extension. Please check your audio system if my voice is not audible at your end. I think it is audible at others end. So, see, some people wrote something else in between. So, what I mean to say, patent 20 years and no extension, trademark 10 years, infinite extension, design 10 years, 5 years extension, IC layout 10 years, no extension. So, these are the things. And someone else was telling 12 years extension. From where that thing came? Can somebody tell me? From where the 12-year came? There is no term in IP Act that is 12-year, uh, having 12-year term. There is no term like that. So if you have any question, you can tell me. Somebody is switching on the video, you can just turn it off, or maybe people are joining right now, that's why. Okay, anything else, any question? So I can write, I can answer it over here. And I wrote all this extension and other things. There was some question from Kila, Kilaparthi Nagaraju. For you, I wrote all this extension, and it might be useful for other. Summary for today's class. This is IC Layout Design Act, valid for 10 years. It has to be original, distinctive, and not commercially exploited anywhere in the world. That is the summary for today's class. Anything else? So I will attendance. I have pasted the attendance link also, and I'm waiting if any other questions are there. I'm here. Sir, I'm waiting for question. Can industries exchange their IC layout? I'm not sure what is your question. If somebody has, if that IC layout is really important for that industry, why they are going to exchange it with someone else? But for registration, if you have your registered IC layout design, so you can license it out so to another company, right? For Jaya Raj. Anything else? So if there is nothing else, no more questions, so I will wrap this class today. The next class is on Monday because Saturday is holiday, I guess, the second Saturday. So next class is on Monday. That will be on Plant Variety Protection Act, and I think that will be my last class on 12th. Yeah. So okay, I hope everyone has got the attendance link. So I will stop the class now. Thank you for joining me. See you on next Monday.